All right. Hello and welcome. Hello and welcome. Welcome to another episode of the Empowered Immigrant Live. Thank you so much for being here uh, and welcome. It is a rainy day here in the Bay Area. It is like pouring down rain outside, and but it's kind of nice. It's kind of nice to have a rainy day. Um, and if you're tuning in and if you're in the middle of the rain, hey, thank you for taking some time and thank you for being here and welcome to today's episode of the Empowered Immigrant Live. Today we're going to be talking about what we call pretermission, which is asylum seekers losing their case without being able to share their story. All right, they're getting their case pretermitted, dismissed, dead, deported. The case lost their case early, ahead of time. All right, and so we'll talk about that as a concept here today. Thank you all so much for being here. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right, so today our topic is pretermission and what that means. And really what we're talking about is asylum seekers losing their case without being able to share their story. All right, getting their case dismissed and denied early so they don't even have the individual hearing. They can't even explain to the judge why their life is in danger in their home country. Okay, so we'll talk about that today. As we're talking about it, if you have questions, feel free to submit your questions. And as always, I like to ask the question, right? Do you want to get a green card? Do you want to win citizenship? Do you want to get VAWA or a U visa or asylum or some kind of immigration relief? Or do you want to at least know what the best strategy might be or what the best options might be for you? If you would like to up-level your life through any immigration legal process, go for it. Do it. I want to encourage you, empower you to do that. And I would love to help you with it. All right, my law firm is on a mission to win 10,000 immigration cases in the next 10 years. We would love for your case to be one of them. All right, as long as you have a case that is winnable, as long as you have a case that is a good case, then, and we take cases that are difficult to win. We love winning complex cases. But we want to be very, very clear from the outset, what are our chances of success, etc., so that we can all make fully informed decisions. And if that would be beneficial for you, hey, we're here to help and we would love to help. Okay? So thank you for being here, whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok, welcome. Welcome to today's episode of the Empowered Immigrant Live. So thank you so much for being here. So, oh man, Ludasad, the Q Lee case. Thank you for asking about that. I'll get to that. All right. So what I want to talk about first is what is pretermission? All right. What does it mean that a case could be pretermitted? Basically, that you file an application for asylum, you file an application for cancellation of removal, and before you even have a trial, the judge just says, nope, we're going to deny you. They're going to pretermit. They're going to pre-dismiss. All right, pre-terminate. And it comes from a case, I mean, there's several cases that discuss this, but there's a very recent case. It's called matter of CARR. It was decided earlier this year by the BIA. And what that case stands for is it says that the immigration judge may pretermit a case, deny a case ahead of time, when the immigration judge finds that an application is, quote unquote, incomplete. All right? What this case also says is when a person fails to include a declaration, and when that's the only thing that they failed to do, that is not grounds in and of itself. That's not sufficient for finding that an application was incomplete. But where there were required questions on your form or on your application paperwork that were left unanswered, or where there were required pieces of evidence that were supposed to be included with the application as stated in the instructions for that type of application, and if they were not included, then in those cases, an immigration judge can pre-termit the case. Okay? And so what's happening and what we're worried will start to happen much more frequently is when Trump now brings in more JAG lawyers and more military judges to hear immigration cases, which when those judges start reviewing their cases, they're going to start looking through, can we pre-termit this one? Can we pre-termit this one? Can we, give me the 5,000 cases of the 100,000 cases that are on my docket. Let's find 5,000 of them and let's pre-termit them all. Deny them all. To get rid of those cases off of their calendars, right? And to deny them ahead of time. And if you're listening to me, you do not want that to be you. Okay? You do not want that to be you. You want to be heard on your case because you want to maximize your chances of winning your case. And so how do we fight against pretermission? And as I'm going, and if you're just tuning in, welcome. Thank you for being here. And as I'm going, if you have specific questions, feel free to submit them. All right, and I'll do my best to answer your questions in a moment. So how do we fight against this? All right, how do we fight against this? And what do we have to do about it? So the first thing that we need to do is when we file an application in immigration court, make sure that every single question is properly responded to, both in writing and with the evidence that's required depending on what type of application you're submitting. Okay? The next thing to do is if the court, meaning the judge, or if your lawyer receives some kind of a motion from the government's attorneys alleging that your case is incomplete for any reason, talk to your lawyer immediately. Okay, you'll want to oppose pretermission. You'll want to submit or amend the application to make sure that it's complete. This very well might, and will for many people, make their asylum cases more difficult. They are looking for ways, they are looking for excuses, they are looking for opportunities from their perspective to deny cases more quickly. From their perspective, that saves them resources, it gets cases over with, they've got millions of cases on their docket. They want to deny more of the cases, and this is the push from the president and from our current administration. It's not good, all right? And so you want to be very cautious about what your lawyer has submitted in your case. And you want to be clear that everything was complete. Every question was answered, all the required evidence is in there, all that, okay? The best advice, of course, is don't go alone. Get support, get a team behind you. Make sure, if you're not clear whether or not your case was properly submitted, get clear about it. Look it over with a lawyer who's good and who knows this stuff and who you trust. And let's take that on. Okay? And that's what you got to be mindful of. I don't want you to get your case thrown out of court ahead of time. I want you to be heard. I want you to have your day in court to share your story, explain why you are eligible for whatever it is you're fighting for, and so that the judge makes a full and complete decision and doesn't just deny you early. Okay? That's what I got today. So thank you so much for being here. Thank you for tuning in. My name's Otis Landerholm. I'm a certified specialist in immigration nationality law, and I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. Thank you so much for being here. So let me get into your questions. I'll do my best to answer each of them. So Luda Sad, you say, can you please explain the Q Lee case? This is a case that came out, I want to say April, might have been May of this year, just earlier this year. And I was in court arguing to get one of my clients who was detained out of custody and show up to court that day. And the Department of Homeland Security lawyer says, sorry, counsel, we're going to oppose your motion and we're going to say that you don't even have jurisdiction. The court doesn't have jurisdiction to hear your bond motion. Why? Because the matter of Q Lee was just decided yesterday. So I'm in court. This case came out the day before I was in court. And they said that that case, matter of Q Lee, took jurisdiction away from the judge to decide bond in my case. Okay? And so Q Lee is very, very important. And what does it say and what does it stand for? What it says is, if a person was initially put into immigration court proceedings through the expedited removal process, 235B1 of the Immigration Nationality Act process through the border, right? They were given a credible fear interview. All right? In my case, my client was given a credible fear interview, passed the credible fear interview, and then was paroled out of custody. Right? If you're paroled out by ICE, they allow you into the United States. They allow you to be released from custody. But what happens if later they detain you? They relinquish, they undo their parole because there's a new political administration in the House. They change their mind. Nope, we're not going to release you anymore. We're going to detain you again. Well, are you eligible for a bond hearing or aren't you? What matter of Q Lee says is it takes you back because you were in expedited removal proceedings, which normally are not eligible for bond, right? Now they have re-detained you. You're now in expedited removal. For my client, they're not in expedited removal proceedings. They're now in asylum proceedings, but they have to fight their case detained. All right, and that is what happened, and that's what matter of Q Lee means, right? So a lot more people are subject to detention who in the past had good arguments to not be subject to detention. And so, for a lot of these people, they have to wait at least 6 months then before they can argue detention, before they can argue that their detention is quote-unquote prolonged and request a bond hearing based on that. Okay, or fight what's called habeas, which is federal litigation requesting a bond hearing or requesting release. So that's my answer, Ludasad. It's a complicated question. It's a complicated case, but it has big ramifications. All right, it means that more people are subject to detention. And so I wanted to clarify that. Thank you so much for asking it. All right, my next question is Ben J. Ben J, thank you for being here. You say, someone who has an expired military parole in place and a renewal receipt while AOS is still pending, should they be worried? That's an interesting question. I mean, your AOS is pending. And so, you're an adjustment applicant. Do you have a work permit through your pending AOS? Typically no. I would say my answer to you is typically no. You shouldn't be worried. Okay? Because your legal status is that you are an adjustment applicant. All right? You were paroled in through military parole in place. Now you're adjusting status. Yes, it's still pending. The worry is if they deny your adjustment of status, then they could NTA you, send you to court because you don't have parole anymore. You say you have the renewal receipt, so maybe your renewal is pending also. Anyway, it sounds to me like you've done it well, like you're doing it correctly. But if you want us to really look at it, feel free to give us a call. But based on what you're saying, I think that you are doing it right. I think you should be okay. All right, and I wish you the best of luck on that adjustment of status application. I hope that you're 100% admissible and eligible to adjust. So as long as that's true, then you should be good. All right. Very good. All right. Rewards loyalty. I see your question. If other people have questions, welcome. Thank you for being here. Welcome to our live session today. All right. Welcome to the Empowered Immigrant Live. I'm grateful to be here with each of you. I love immigrants. All right. I was meeting with a gentleman just 2 days ago who told me this horrible story. He was in his home country. One night, it was midnight, he wakes up and his house is on fire. All right? And it's him and it's his wife and their, I think, 2-year-old son were inside their house as flames are climbing the walls of their house, burning their house to the ground. So luckily, he woke up after hearing the flames. All right? And he got his wife and his son out of the house. Later, they found out that that fire was not an accident. It was arson. There was somebody that was trying to kill them. But he didn't know who it was. He didn't know why they were trying to kill him. So he fled to the U.S. and he fought asylum. But here's the thing. He lost. He lost his asylum case years and years ago. The thing about asylum is you can't win asylum if you don't know who was persecuting you or why. Right? Like, you have to show, to win asylum in the U.S., you have to show that you suffer persecution or you have a well-founded fear of persecution on account of your race, religion, nationality, political opinion, or your membership in a particular social group. In other words, if you're not sure why they were harming you, and if you can't show that it was because of your race, or your religion, or your nationality, or your political opinion, or your membership in a particular social group, the judge has to deny you. Right? So anyway, that was this case, and I'm in a consultation, and I'm meeting with him, and I'm asking him all kinds of questions. And guess what? It turns out that a couple years ago, he was the victim of an attempted robbery. All right. And so I'm like, okay, wow, what happened to you in your home country is horrible. We can't use that. But if you were the victim of a crime in the U.S., then you might be eligible for a U visa. Let's look at that police report. Let's get to the bottom of that. Let's see if we could actually, help you and your wife and your son through some other means, because the asylum case is not going to work. And he's like, okay, cool. Let's file a U visa. All right. And so, sometimes it's like, people might call us thinking that they have one type of case and really they have another type of case. But I wanted to share that because that was a remarkable story. What people go through sometimes is intense and crazy, brutal, right? Anyway, thank you all so much for being here, and welcome to the Empowered Immigrant Live. I am really grateful to be here with each and every one of you. All right, rewards loyalty. I see your question here. You say, traveling with a green card and a 212H waiver issued by a judge, can CBP deny your entry? I'm out of removal. All right, so I get that, right? You won your removal case, you won your green card, you won your 212H waiver. Can CBP make a new determination that you're inadmissible? Really, no, they can't. All right, it's already been waived. All right, it's already been waived, but you want to be cautious. All right, talk it through with your lawyer. If there's any new crime, if there's any new reason for them to find you inadmissible, then be mindful. There are some situations where you don't want to travel. Okay. And you also want, if you're traveling and if you're clean since the date of your judge's order and you're traveling now, you still are asking the right questions like, should you be nervous about CBP? Yes, you should. And you should travel with your green card and the order by the judge signed granting your 212H waiver, so that you can document, and your criminal records. And your certified court dispositions for the criminal records, so that you are very clear with the procedural history. Like, yes, I did this. Yes, I showed it to the judge. Yes, the judge granted the waiver. Yes, here's my legal green card. Yes, I'm legally eligible to re-enter the United States. Any questions? Let's bring a supervisor in. Call my attorney if you need to, right? Like, that's the type of situation that you're in. And so, yeah, you should be okay, though, as long as all those things are there. Talk it through with your lawyer if you want specific legal advice about your specific situation, because I don't know exactly all the facts in your case, but I've certainly had clients of mine where we were in that situation. We won a green card, we won a 212H waiver, and they have traveled outside the U.S. and re-entered without issue. Okay? Very good. All right, live in style. I see your question. Is it safe to travel domestically on a pending asylum? So, yes, it is. If you have a work permit through asylum, if you have a real ID driver's license based on your work permit through asylum, those things help. All right. If you have pending asylum, but you entered the United States without permission, then it's a little bit trickier, right? Because if you entered the United States without permission, then if you had an issue in certain parts of the United States, if you were detained for any reason, they would argue that you can still file asylum, but you're subject to mandatory detention. That's the matter of Yahure Hurtado, all right? And that was decided by the BIA earlier this year. It's a horrible decision. I think it needs to be overturned, but so in other words, yes, kind of. You're kind of safe because you are an asylum applicant, which is a legal status in the United States of sorts. It means that you have a pending and lawful application for asylum. You have receipt notices. If you have a work permit through the asylum case, that's even better, right? Just be mindful and cautious that if ICE or if Border Patrol or if law enforcement were to detain you for any reason, you'd want to know your lawyer's phone number. You'd want to really be clear about, okay, what would the arguments be to get you released? Because if you can't get released, then you have to fight asylum while you're in detention. And that's because of the matter of Yahure Hurtado, as I was talking about. All right, mandatory detention if you entered the country without permission. All right, if you entered the country with a visa or with parole or some other form of relief, then that doesn't apply to you, right? And so then if you were detained for any reason, you could request a bond hearing and get bonded out. All right. So anyway, that's the answer. That's the answer. I hope that's useful. Hope that's helpful. All right, folks. Any other questions that are out there? And if you're tuning in right now, we got a couple things going on in my firm that I want to give you a heads up about. So one is on December 12th, on Friday, December 12th, we are going to have a special conversation lunch for free at 11:30 to 1 p.m. It's a lunch for immigrant business owners. All right, so if you're an immigrant and if you own your own business, please feel free to come in. And, I am a business owner. I love being a business owner. I love supporting immigrant business owners. We have a lot of clients who own their own business. And so if you're in that situation, free lunch on me. Feel free to come in and zero strings attached. And let's talk business and let's talk your cases and let's talk it through, like how can we best protect you and best support you. Okay? So I wanted to share that, and we'll put a link in our description of the video. And if you don't see it, then please feel free to reach out to our office also. I think some of the platforms it might take a minute to show up in each of the platforms, but we will put it there. All right, Maria Lacerda, I see you there. You say, I see that some attorneys have no idea or experience about habeas corpus and the petition 245I petition. Can you talk about both in separate videos? People can use 245I if they have a U.S. citizen petitioner. Yeah, I don't see the rest of the message here. But yeah, okay. Yeah, noted and thank you. And many attorneys have very little experience with both of those things. 245I, I mean, I'll just share myself. 245I, I have a lot of experience with 245I. I have very limited experience with habeas corpus. And so I can talk to both of those. All right, I'm actually going through learning. My office is doing our very first habeas corpus motion, writ, petition right now. Right, we're finalizing a reply brief on a preliminary injunction in federal court for the purpose of getting a client released through the habeas process. So we know about it, but we are in no way experts in that area. But I can talk much more about 245I. The quick version is for people who were physically present on December 20th of the year 2000, who had a petition that was approvable when filed and actually was filed before April 30th of 2001, right? If you have if you're in that situation, then you can adjust status even if you entered the country without permission, okay? So it's an exception to the requirement that a person be inspected, admitted, or paroled in order to adjust status. What you do instead is you pay a $1,000 penalty fee and you can adjust status in the United States. You do not have to leave. You do not have to consular process. It doesn't waive other inadmissibility. So if you have a permanent bar or something like that, or a false claim to citizenship or a immigration fraud or smuggling issue or whatever, if you have other inadmissibility, it does not work. It doesn't change that. You might still need a waiver for those other things, but it can forgive the entry without inspection, right? As one of the requirements for adjustment of status. All right, so that's 245I, and sure, I get that that's a lot, and I can do a whole video about it in the future. I have done videos about it on our YouTube channel. You can check that out. And I will certainly do videos about habeas corpus in the future. I just want to have success in our first habeas corpus case and continue doing the trainings. I'm actually flying down to Long Beach later today, and I'll be getting some training on habeas. And there's another training I'm attending next Wednesday because the demand for habeas right now is enormous as more and more people get detained by ICE, right? Yeah, habeas is the way to challenge your detention when that detention is unlawful, when that detention violates the U.S. Constitution, all right? And that's what habeas corpus is about. All right, live in style. I see your question. You say, yes, real ID and a work permit. Yeah, good, good. If you have real ID and a work permit, then really your safety goes way up when you're traveling domestically, right? Real ID can be used to get on an airplane. Your work permit, I mean, you have lawful status in the U.S. as an asylum applicant. That is your status, all right? So, very good. All right, folks, that is our session today. I don't see any other questions for right now, so thank you all so much for tuning in here. I really appreciate each of you. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. If we can help you in more depth with anything regarding your specific immigration case, please feel free to reach out. We are here to help. We would love to help, all right? If you're an immigrant business owner, please follow the link in the description. We'd love to have you join us for our upcoming Immigration Business Owners Lunch, all right? And so that's taking place on Friday, December 12th, and you know, love to have you there. All right, everybody, thank you all so much for being here. Really appreciate each of you. If this was useful, if this was helpful, please take a moment and subscribe to our channel or give us a thumbs up or a heart or, you know, like us, share us with people who might be might benefit from this content. I wish you the very, very best day today. Don't slip and slide in the rain. There's a lot of rain here in the Bay Area. Be mindful of that. Make it a great day, folks. Really appreciate each of you, and we'll see you next time on our next episode of the Empowered Immigrant Live.